because I'm 24 years old. I turned 24 November the 6th. I lost my mama last year when I was 23, and I'm a single mother. So my mama was my everything for me. So I don't know if that makes him feel any kind of way, but I just really hope that he can take heed and consideration to the damage he's caused and sit and reflect on his actions and realize what he has done. And I hope, moving forward that he don't make this same mistake, because it could be another mother or another father, or it could be someone else. So I just hope moving forward, for future references, that he think about, that his choices and the things that he do, because like you said, you know the difference between the accident and the mistake.
Morning. Good morning. What, state your name again for the court reporter?
Juana Stiggers Fletcher.
Okay.
And Giovanna was my sister. And I know this hearing is just for compliance, but as doing my research, it says that he could be possibly taken off his ankle monitor due to if he's been compliant. But I feel like, and I know we have laws, but I feel like he should not, because what really just hurt my heart is at his original bond hearing. At his original bond hearing, he stated he wanted to go home to be with his disabled child, which my nieces and nephews don't have their mom here. And I know as we stand here, it's only accused, but when the state proves, it will not no longer be accused, it will be guilty. It's very hard for myself to follow rules and regulations of the law, and for other people not to follow rules and regulations of the law and just get to go about their merry day and go home to their families and go home to their children is very unfair. And this is just not something that a word sorry can reverse. Sorry is something that you say, oh, I stepped on your toe, I'm sorry. But in this case, the word sorry is just not gonna cut it, because you're being in compliance with what somebody made you do. It's not okay. I have 6 nieces and nephews that I have to look after now. The oldest only being 26, which has to take care of his siblings. And I think just by you just going on your merry day and not, I don't know if he's sorry or not, or I don't know how he's thinking. But as for our family, every day, and I mean every single day, I have to get up, I have to call a therapist because I can't function. I can't wake up without crying. I can't go to sleep without crying. I had to move from the area that I lived in because in 45 years, we've never been apart. And just by going by the accident site, 2 minutes from the accident site, I have to pass the site by going anywhere. So I had to relocate so I can just get away from the area. And her children want to relocate because they're 2 minutes away from the accident site. But it's hard for a 26-year-old to just up and move with minor siblings that you now have to be the legal guardian of. I just want the court to take in consideration of the severity of this charge. I know, like with me doing my own research, and his charge is considered a low-class felony, but I have reached out to some House of Representatives to see if we can get this laws changed. because I feel like a magistrate court judge should not have been able to grant bond due to the severity of this charge. I just want the court to just take in consideration the severity of this charge and allow him to stay on whatever supervision, because it only takes one time to do something that you originally did and another life will be lost. I don't know if our children want to say anything, but I just want the court to just realize the severity of this charge.
Thank you, ma'am. All right, what says this, anything else from the state?
Yes, Your Honor. So the state is asking that.
Well, I want to say something.
Go on, sir.
Hey, how you doing?
I'm well. Can you state your name for us?
My name is Venus. I am my mother's third oldest daughter. So I just want to pick up where my cousin left off. Basically, you know, when we are a teenager or, you know, teenager, adolescent, adult, we know you don't drink and drive. We know that off rip. You know, we know you don't drink and drive. That's, you know, the severity of it. So like she said, I don't know if he feel, you know, any way about what he did, or if he realized what he's done or the damage he's caused to a family, because it is 6 of us, and our mother, she was our anchor. And, you know, our mother, she did everything for us. She took pride in being a mother. And like my cousin said, it's just very unfortunate that this situation happened. You know, I just hope that he can live and learn from this situation and realize the severity of the damage he's caused to this family, because you don't drink and drive. And like she said, you can get back in the car and it can happen to another person. So you just want to be cautious and mindful of the things and the choices that you make in life, and understand the effect that it can have on people. Because I'm 24 years old. I turned 24 November the 6th. I lost my mama last year when I was 23. And I'm a single mother. So my mama was my everything for me. So I don't know if that makes him feel any kind of way. But, you know, I just really hope that he can take heed and consideration to the damage he's caused and sit and reflect on his actions and realize what he has done. And I hope, you know, moving forward that he don't make this same mistake, because it could be another mother or another father, or it could be someone else. So I just hope moving forward, you know, for future references, that he think about, you know, that his choices and the things that he do, because like you said, you know the difference between an accident and a mistake. So I just hope that, you know, he can find it in his heart to forgive himself and realize what he done. To him, this may just be, oh, hit and run, you know, but somebody died. A mother lost her life. We lost our mom. A grandchild lost their grandmama. So it may not be a shooting, or it may not be, but you still killed the person. And I feel like people should be held accountable for their actions. Like, you don't just get a slap on the wrist for killing the person. So I just hope moving forward, you know, he can find it in his heart to realize what he has done and hold himself accountable. Because drinking and driving, I don't know. But yeah, that's all I have to say.
All right. Thank you, Ms. Venus. All right, go, come on up, counsel.
So, Your Honor, the state would ask that this incident occurred in February of last year.
Right.
And the defendant wasn't arrested until sometime in August of last year. And that was based on the ongoing and continuing investigation into that. So the state would ask, at least, Your Honor, until this indictment, that this ankle monitor not be removed.
And do we have any kind of violations?
So we don't have any violations within the last 60 days. Mr. Hunter is very communicative with us with his whereabouts.
Bostic, anything?
No new arrest, Judge. He's had it on since 8/31/25.
Okay. All right, go ahead, counsel.
Yes, Your Honor. Since the defense agrees, this is an extremely unfortunate situation for everyone involved, for the family, for the victim, and even for himself. The total lose-lose situation for everyone. And he's expressed great remorse. And since this time, he has not had any alcohol or any drinking, nothing related of the sort since this situation came about, Your Honor. Also, since he's been on house arrest, he's been at home, very compliant with everything he's supposed to do. The one thing that has happened to him is that his house is burned down. This, not yesterday, Sunday, but the Sunday prior, his house is burned down. And so he's been moving from place to place with different family members and Airbnbs. His life has taken a turn for the worse. And so he's trying to put the pieces back together as much as best as possible. He's doing everything he can with the system, and he intends on fighting this case out to the end. Well, however it goes, Your Honor. He's not running. He shows up to court whenever he needs to. And so as the law dictates, that we just ask that you consider removing the ankle monitor to give him the opportunity to hopefully get a job, or because he have 6 kids. One of the kids you heard being disabled. And so he would like the opportunity to at least work and produce some sort of income for them in this meantime, if possible, Your Honor.
Where would he plan on working?
Right now, I do janitorial.
Do you have it been working?
Not this past week because the house fire.
Okay, yeah, it says he's able to work. All right, well, we'll leave it on a little longer and make sure you supply your new address. I'm sorry to hear that your house burned down. That's pretty awful also, but make sure you provide the address. And if you're going from place to place, I understand, but just let the ankle monitoring company know, okay? All right, we'll see you back. Thank you, sir.
All right, thank you, Your Honor.
Okay.
May I be excused?
Yes, sir. Have a good afternoon. So number 3, Mr. Martin has been deported. Let's see, number 4, Jake Herman, 25 PI 006537. Huh? Yeah, Jake Herman. All right, well, let me just, have they turned his off?
No, we're still tracking him. He's in an outpatient facility in Orlando, Florida. So no,
Okay.
Outpatient.
Well, yeah, that's what she said.
he told us it was outpatient, but
Your Honor, I cannot hear whoever just spoke.
Need to hear, yeah, you don't need to hear her. She's just, it says partial hospitalization. All right, any violations there from the ankle monitor company?
we do have one dead battery on December 14th.
All right, so we'll just keep this on for another 6 months then, just, since we can't really hear from him. All right, let's see. Number 5 is Kinsey Price, 25 PI 007598. All right, go ahead. What you got, second chance?
So the defendant does have a bond condition that they're not to be within 1,000 feet of the school or residence. The defendant has entered within 1,000 feet of the exclusion zone on 126, 220, 222, 223, and 224.
Lost it. What do you got?
No new arrests. Has had it on since 9/18/25.
All right, go ahead, counsel.
Judge, let me just have an opportunity. Could I, again, what were the violations in which specific school is it, is it just all schools or one specific school?
It's around the Cohen Street, the school that's located near the neighborhood. Is you stay away 1,000 feet of the school or residence. The dates are 126, 220, 222, 223, and 224.
Your Honor, my client is stating that she does have small children who go to another school that might be in the same area. And so when she's walking them to school, that may be why she has violated being near this school. But I guess we need to tell her that she needs to take another route and make sure that she is not within, what is it, 1,000 feet? She is not in 1,000 feet of the school. That's the violation.
What says the state?
Yes, Your Honor, the state is asking based on the violations that this ankle monitor continue, that there's no modifications. Now, I'm also noticing that we have not been able to contact the victims, but the state nonetheless still asked that no modifications be made at this time.
Turner, we would ask that that we put back on the calendar in 3 months to see whether or not her being able to take another route to take her child to school, and if there's no violations, and then at that point, we would ask for the monitor to be removed.
We'll put it out another one, and I mean, because you only got 1, 2, 3, 4 violations, so obviously you've taken different routes before, so yeah, take a different route. Don't go by the school anymore, okay? All right, we'll place it back on another calendar.
All right, thank you, Judge.
All right, let's see. What about Charlie Varner, number 6, 25 PI 007608?
We're
Yes.
finding information. If you can call her if you have any issues. Okay. All right. Mhm.
All right, what you got, second chance?
Yes. Good morning.
Good morning. So we don't have any known violations within the last 60 days with the defendant.
Boston.
No new arrests, had it on since 9/17/25.
All right, go ahead.
Good morning, Your Honor. Kwame Thompson standing in for Clarence Johnson on behalf of Mr. Varner, who is present. Mr. Varner has remained compliant with his court supervision and has appeared as required. Since bond was imposed, the parties have not been in contact, and based on the conditions, we request the removal of the ankle monitor. We respectfully request the removal of the ankle monitor.
All right, what says the state?
So the state is asking that there be no modification to his current ankle monitor. The last contact with the victim, Your Honor, was in September, and she expressed that she still is in fear of this defendant, in her words, peeping through her window, and she's just haven't been able to recover from that, Your Honor. So as such, the state is asking that there be no modification.
And Your Honor, our client, Mr. Johnson and our client, he has been working, he has been in compliance, and the ankle monitor shows his movement. So he has not been peeping in anyone's window.
The warrant was issued in December.
The warrant was issued in December
2024.
2024, okay. 2024, you have no contact.
There, I don't see a TPO. Is there also a TPO in place? I don't see one here. Do you know?
Is there a TPO in place?
No,
No.
not that.
Okay. Where is this as far as indictment, do you know? This is history.
Glenwood, that's what it is.
Just a second.
Oh, did you ask me? Oh, I'm sorry, Your Honor, I didn't hear. Let me look.
Stacy, you actually for us. Not in 20 years. Nothing like this at all.
So I'm not seeing, Your Honor, that he's on the calendar for this week. I do notice what my guess, Your Honor, in that the recent contact with the victim, ordinarily when the case intake gets them, that is how they reach out to prepare those cases for indictment. So my estimation is that that's what was happening coming up to the holidays. So I anticipate, Your Honor, that if not this cycle, the next grand jury cycle. But I'm not showing that he's on for this week.
Go ahead.
Yes, Your Honor, the purpose of bond conditions is to ensure appearance and community safety. Mr. Varner's compliance demonstrates the current restrictions are more burdensome than necessary.
All right, I tell you what, why don't you go by on the 16th? So that'd be a year, March 16th to get it taken off.
March 16th. Thank you.
Thank you, Your Honor.
All right, have a good
See
one.
you again.
Yes, sir.
May we be excused?
Yes, sir.
Who does he report to for that?
Second chance. On the 16th.
16. Okay, thank you, Your Honor.
Thank you. All right, Aaron Hilliard, number 7, 25 PI 007990. Aaron Hilliard. Oh, anything from, this your client? Anything from the state?
Yes, Your Honor. State moves to forfeit bond and issue bench warrant.
Also, I guess we need to do an order, don't remove his ankle monitor if he comes by on March the 29th.
I'll put a note.
All right, so why don't we'll go ahead and extend it too for another 6 months. That way, till we figure out how we're gonna deal with that, okay? All right, let's see, number 8 is Krishana Harper, 25 SC 007916. What you got, second chance?
Your Honor, defendant does have a bond condition of 24-hour house arrest except for work,
Defender's
medical,
office.
legal. She is allowed to travel to the Walmart and pick up her child. The defendant does have several curfew violations. She has a total of 20 curfew violations where she is tracked at shopping plazas, restaurants, liquor stores, movie theaters, apartment complexes, residential homes, gas stations, hotels. And defendant also tracked out of state in Chattanooga, Tennessee from 2/13 to 2/20. We did contact her asking why she was tracking out of state, to which she said it was approved by the court and that we told her we would have to have notification and the approval, and we still have not received that. And we told her if that was approved, she would still have to abide by her 24-hour curfew, to which she didn't.
What about it, pre-trial?
No new arrests, got out 9/6/25.
Go ahead.
Your Honor, according to Ms. Philly's notes, she does have bond plea and arraignment, or no, I'm sorry, she must have had it already. Your Honor, we would just ask that. Sure.
My job, I'm a caregiver, so all those shopping plazas and movie theaters, they're out there for my client. So I travel with her on a daily basis.
Good.
So I take care of her, and that's part of the work. And so as far as being in Tennessee, I talked to Miss Stacy Levy in the last courtroom. That was my public defender. My public defender has changed quite a few. And she was the one who told me, because that my client was going out of town for that week for a memorial service, that I'm homeless because of this whole situation. So I had to go back home. I'm from Chattanooga, Tennessee originally. So that's why I was there for those amount of days. And then I returned. All of the during the day, those shouldn't, that's work. I'm doing that work. I have documentation that I'm working. That's not just me going to these different places because I want to, or it's with my client. And I have that documentation here, as well as notice from her going places because I want to be, out and about. This is work.
So Judge, is the part of the condition is that she is allowed to go to work? And if she has proof that these, violations are that she is going to work, then I suppose they would not actually be violations.
So, I mean, where is she working?
I'm a caregiver. I have a patient that has dementia. And so basically I take her to her appointments, I take her shopping, I take her to do things to keep her mind stimulated, such as movie theaters and things like that. We go out to eat sometimes during the day. That's it. And so I'm allowed, so what they do is they allow me to stay with her overnight because I am in a homeless situation right now because I lost my home due to this whole arrest. So, and I have paperwork showing where I was evicted and things like that because of this arrest. I have all of that here. So I'm not just violating. I didn't even know I
So
had.
you don't take her by a liquor store?
Yeah, well, no, sometimes we have went to a liquor store before and, it's
Wait,
not even
buying-
her, it's her daughter so her daughter is the one who usually goes to the liquor store. She's here in town with her mom. And so she drives us. So sometimes she stops by liquor stores, she stops by.
But you don't
gas
have to be
stations.
with her.
No, well, I'm the caregiver, so I'm in the car when they go. It's not like I'm going inside of the liquor store or I'm going shopping for liquor. I haven't had a drink since this whole situation happened or before actually. So I'm just riding and as a passenger because I don't have my own vehicle right now. I'm riding with them. When we need to take her places, she drives us. She sometimes drops us off. Sometimes we live. It just depends. So those liquor stores are mainly when she just stops by when she gets off work or whatever. I don't know. But sometimes I ride with them everywhere. So it's not like I'm driving to these places and doing these things. It's just that I don't have transportation, but I am her 24-hour caregiver in a sense. So when she takes us places, I can't control where she stops or, you know what I'm saying? And I even have a notice from her where I let her know, I'm like, look, I can't go a lot of different places that I can't prove. And she's like, well, I can vouch for you like that you're riding with me or whatever, which is, again, not something that I can control, but I'm not going to these places, like for myself. These are places, even the apartment complexes she was looking for shelters for apartment for her mom because we're all staying at her one house right now. And she was looking for a place that would accept her and her disability. And because she originally was from Florida,
Hold on a second. So why'd you go to Nashville or to
Chattanooga is where I'm
Tennessee?
from. So they had to Florida, which is where they're from, for a memorial service, and I couldn't stay at their home. So
So let me ask you a
Miss
question.
Levy.
So hold on. So what are you going to do so that families, Bank of Modern Company knows where you're at? Because there's nothing on here even mentioning any of that on your bond condition.
Well, I'm not sure. So I spoke with Miss Levy.
Hold on, Judge. So we would ask that, that her bond, if her bond conditions do not allow her, so now we know what she does, that we modify her bond conditions to allow her to continue to be a caregiver for
Miss Yvonne Rayford.
Miss Yvonne Rayford,
Mm-hmm.
and that in the future that she can provide, she can let the ankle monitor people know where she's going with her patient.
Also,
Go ahead.
she asked.
What says the state?
She said.
So, Your Honor, so the state, her tracking from the monitor company, Your Honor, is showing the exact opposite of what she just said to the state, to the court. Based on her tracking, it appears that she absolutely is out and about. There's several instances where she's gone to hotels and spent the night at hotels. There's instances where she's gone to movies, and leaving the state without asking for permission. As far as the anchor monitoring knows, she was supposed to be working at a BP gas station or something of that sort. They don't have any instances where she even showed up to that job. So if she is working as a caregiver, she didn't let us know that, or the anchor monitor know that. So now she was indicted, Your Honor.
Yeah, I got that. Yeah. So
And she has not been arraigned yet. So the state would absolutely be opposed to any. In fact, we should be probably put more conditions on because she clearly hasn't abided by what's in place right now. So for that reason, Your Honor, the state is opposed to any modification.
Your Honor, I think she explained to the state what was going on, and she stated that all these different places that she went to was because she was with her patient because she's the caregiver. But Your Honor, the case has been indicted. She hasn't, you haven't had a court date. Have you had a court date on?
No, so I haven't even gotten a
Okay,
chance
when-
to speak with
okay,
anyone
okay,
in
when-
reference to this. I did let the ankle monitor, I did work at the BP.
Mhm.
I have proof of that as well. I have check stubs and all of that.
Mhm.
So I did work at the BP, but I ended up not working there
Right,
after.
right, I understand that.
So what is, so as far as going to Tennessee, it was because, and I spoke with the lady upstairs and I was in courtroom 5.
Okay, well, I don't know what you said to Miss Levy, so.
Well, that's why I thought it was okay, because I let her know that my client was going to a funeral. So she said
I
that
know,
she
but
would put it in the bond modifications and speak with
Well,
that judge.
Apparently, I don't know whether that.
So I would have never left.
All right, here we go. So, I mean, because no, that whole right
I
to
haven't
remain
had a
silent
chance
is not
to
really
even
working.
speak with my
It's
counsel.
don't talk, if you speak to your counsel loudly. So we're hearing everything you're saying. That's not what we're supposed to do. So I'm going to extend it, but I mean, you've got to keep them in, let them know what you're doing, because this is like you went to a hotel. You stayed at somebody's house from 12:53 to 3:45. Then you traveled to Walker Road in Chattanooga, which appears to be assisted living facility, from 4:18 to 5:25. Then you drove back to another residence to stay for like 10 minutes. Then you went to Hickory Valley Road in Chattanooga, Tennessee, to a BP gas station. So up there, you're just kind of, bopping all around, and
Because I don't have a
that's
home.
not, okay, I'm just reading it. So we're gonna extend it, but so where, you gotta let them know right now where you're living. They need an address where you're living and what you're doing, and you need to make more phone calls to them. But if the lady's daughter needs to go get alcohol, well, you guys don't need to ride with her.
Well, no, it's not that we're riding with her.
Okay.
It's like a stop.
Okay, sorry. So, yeah, Judge, that's fine. So we would just ask that, so you just need to let them know whenever you're
No problem.
going
I
somewhere.
was
just-
doing-
You gotta update your address, your employer,
I don't-
show proof of employment and the schedule. So if you're staying there 24 hours, you need to let them know, but you cannot travel out of state unless you get permission. And typically, I mean, there's this is a sign of Judge Carnsell, who's completely reasonable. If your lawyer calls and asks, I'm sure Judge Carnsell will say, absolutely. So,
That's my, I
but
thought
they'll
that-
usually do an order that's put in here, because if it's not in here, then it didn't happen. I'm not saying you're lying, okay? But you just got to follow up, just like, hey, you make sure, I mean, there's nothing wrong with reminding the rest of us, make sure that something's in writing so we'll know. All right?
Yes.
So we'll see you back. Thank you, ma'am.
Okay,
Your Honor,
thank
the
you,
state
Your
would
Honor.
ask that she update her address.
Yeah, update your address and all that with them. You got to keep it updated.
Okay, so right now, that's what I was trying to explain. I'm currently homeless, so I'm
But you say
staying-
you're staying with the lady you're taking care of.
Right, but they're, okay,
Well, just
right.
put that address down for
Okay,
now if
okay.
you're staying there. And then if that changes, you just need to let them know.
Okay.
Okay.
Well, I would.
All right, so we'll go to number 9, Jacqueline McCleskey, 24 SC 003322.
Can I fill this out over here?
Yeah, you can.
Jacqueline McCleskey. Not good.
They would ask for a forfeiture of bond and a bench warrant, Your Honor.
All right, and we'll also do, we're not going to remove that ankle monitor. So we'll extend that one.
Your Honor, he's been dead since 113, and he has a ton of dead batteries that are totaling up 329 hours at a time.
All right, so we'll do a bench warrant and extend the ankle monitor. All right, number 10 is Emmanuel Scott, 25 SC 003866. What you got, second chance?
So defendant does have a 24-hour curfew except for first school, medical, attorney visits, anything approved by pretrial officer Singleton and must attend school or GED program. The defendant does have 20 curfew violations within the last 60 days. He's been tracked at apartment complex, residential homes, and gas stations. And all these violations have been sent to pretrial weekly for all violations.
All right, Boston.
No new arrests had it on since 10/7/25.
Job, pretrial. All right, well, go ahead.
Morning, Your Honor.
Yeah, Your Honor, my understanding of it is, you said convenience stores or gas stations?
Apartment complex, gas station, residential.
I believe they're all in the same area, for the most part, which is near the school. He attends the GED program at the Promise Center. The staff have spoken to him, about the fact that he's not able to leave the center. When he's there, he needs to, attend the, classes and then go back home, as well as he has permission from me to participate with his grandmother at the church on the weekends. And so we'll just tighten that up so that he's not moving around as much.
So you didn't know before that you couldn't run over to
the gas station,
It's right
right
there.
across the street.
It's right there. And so they get a break at the program. And he's been going over there, but the staff there know how, I have several people in the program and have had for years. And so they know that I don't really let them move around like that. So they've spoken with him as well. And then they contacted me last week to let me know how well he was doing, but to let me know that they spoke with him about going to the store and stuff.
And Your Honor, my understanding is that the staff at the Promise Center has commented to Ms. Singleton about how very smart Emmanuel is, how well he is doing there in school, and they're really proud of him there.
Yes.
What's the state?
So, Your Honor, the state ordinarily relies heavily on Ms. Singleton's opinion. And based on what she just said, we're not going to ask that this. He obviously has some violations, and because of the nature of the offenses, we normally would ask to be taken into custody, but for the sake of Ms. Singleton, because we know we have confidence that she's going to get him on the right track. So
take Ms. Singleton into custody?
And Your Honor, just so that the Judge Schwall did sign an order this morning extending the monitor. I believe that it was supposed to come off on March the 4th-ish.
Right.
And an order was signed this morning extending it until further order.
I'll do another one just in case, because I don't see it in here.
Yes, Your Honor.
but are you putting the time on that, Your Honor? Just
No, just until, like, if Judge Fall says until further order, because I don't see it yet, but we'll make sure, okay?
All right.
All right, thank you.
Thank you, Your Honor.
Thank you, Your Honor. May we be excused?
Yes, ma'am, have a good one.
I'll take care.
Number 11, Carlos Thompson, 25 SC 006144. Carlos Thompson.
Is this guy?
you, Carlos.
All right, second chance, what you got?
Your Honor, the defendant did start tracking this morning. His battery was dead since 12:15. Oh, I'm sorry. He did come in on 224 to get a charger in our office because we contacted him multiple times. It was dead from 12:15 to 224. He stated that he was trying to catch a ride to our office. I told him that was a priority and that his conditions are that he has to keep his monitor charged. After reviewing the charger, it seems that his dogs like to chew on it.
Bostic.
No new arrests. He's had it on since 9/28/25.
Go ahead.
The reason why that your ankle monitor.
Oh, no, I just, I ain't, when they can't contact me because I don't have no number. I don't got no number for them to contact me. I don't got no phone number.
I know, but how
I'm
come?
getting a phone number nowadays.
Okay.
Charger been broken and I went.
Well, did you go?
I
No, but
did.
okay. When did you go and get your ankle
She just
monitor?
it went like a couple of days ago.
Broken.
Chill.
Your Honor, excuse me, Mr. Thompson stated that he doesn't have a phone. It was hard for him to get in contact with them, but it's my understanding that he's gone to talk to them. He does have a new monitor.
He has a new charger.
He does have a new charger, and so there shouldn't be any more issues. And
Didn't you say he hadn't been charged since he got a new charger?
No, it started tracking on
Oh, okay.
224, yeah.
Well, it looks like you might want to have a seat over here in the jury box. 'Cause it looks like there may be a hold for a failure to appear in front of Judge McBurney in December. Okay, just have a seat over there.
In December?
Yep,
In the cab?
Judge McBurney here in Fulton.
Yeah.
all right, yeah. I like the calendar.
Where we at? What number we on there?
Number
12.
12.
12, yeah, number 12. Matthew Matravion, is that right? Matrion, 25 SC 007846.
Good morning, Your Honor. Before we start, I want to observe that the court that Judge Madden needs to know I was not here early. I was not here before 9:20. If she thinks I was here early, it's going to ruin my reputation.
Exactly.
Here I am. Good morning.
Morning. All right, what do you got, second chance?
So we don't have any violations within the last 60 days, but we do need updated contact information because the phone numbers and stuff that we do have on file for the defendant are no longer,
All right.
No new arrests. 9/5/25.
All right, looks like, what, there's a trial date for June?
Your Honor, if it please the court, Mr. Myers, and I'll never pronounce his name correctly, so I apologize to him and to the court. But he has, to the best of my knowledge, been in full compliance. He is living in Sandy Springs, renting a room at how do I phrase it? A girl who is a friend of mine's house. And I would ask the court to consider removal of his ankle monitor in that I personally don't see the necessity for it any longer. And hopefully the DA's office won't disagree. But again, Bonnie's not here.
Well, so he is on track for trial in June, Your Honor. I was just reading the victim's notes. And the last contact with the victim was on the 9th of February. And back in December, when we spoke with the victim, they had expressed an interest to not have any modification to any of his release conditions. But as of February the 9th, they didn't express any of that. So, I mean, it is on track for June for a trial. So the state's position obviously would be to leave everything in place at least until that trial date.
Your Honor, if I may address the court as well. Matthew has been receiving extensive counseling. His demon, as with so many other people, is alcohol. He is abstained from alcohol. He is continuing to get counseling. And I would ask the court and urge the court to allow him to remove his ankle monitor so he can wear shorts again in public.
I said hi, please. Sir.
I mean, these are some pretty serious accusations. So there's been any sort of violations at all?
What was that, Your Honor?
I said it's pretty serious accusations. There hadn't been any violations whatsoever.
No violations, Your Honor, but just based on the expressions of the victim, Your Honor, that, they were still expressing some fear of this individual.
And I would point out to the court, this was all by phone, which doesn't make it better. It makes it more stupid.
Right. You're supposed to something on LinkedIn, looks like, allegedly. You gonna say something, Boston?
No.
But there hasn't been any violation since he's been on the monitor with us.
All right, we'll remove it.
Thank you.
Will? Yeah.
Thank you, Your Honor.
All right, let's see. I've got number 13, Darius Green.
Your Honor, may I address the court one more time?
Yes, sir, go ahead.
Have a great day. That's it.
You say she removed it. Don't make her put it back on.
Darius Green, 25 SC 003-852.
You are, but you can bring it to us.
Just still funny.
Okay, where's your
We have
13 and 14.
I'm saying this spring.
Yeah, and 14, 25 SC 003-879, Darius Green. Last call, Quadarius Green.
State moves for forfeiture bond and issue a bench warrant, Your Honor.
And Your Honor, I would just like to notate for the record that he has not tracked since January the 14th. And he has several dead batteries ranging from 27 to 77 hours at times.
Yeah. Oh.
Yeah, all right, so we'll extend that ankle monitor till further order of the court too, and do the bench warrant. All right, oh, and that was number 15, I said. All right,
That was number 13, right? Your Honor?
well, it's 13, 14, and 15.
Oh, okay.
So we've done number 16, number 17, Jemiah Sullivan, 25 PI 000643.
Honor, if you could, that is That is gonna be Mr. Showalter's case. He had to run to another courtroom, so if we could hold for his report, I just text him, he's on his way.
All right.
Did that individual answer the call?
Yes.
Oh, okay.
All right, so we got Ethan Brown, and I think he's in custody, right?
Yes, he's been in, since 1/5/26. He has an ankle monitor on this and he got.
I know, he doesn't have one on at the jail. Do y'all remove it?
It was removed when he went in on January 5th.
Okay.
Is he here? He is. Judge after the count, I was gonna talk.
Okay, that's good. What about, all right, we got number 19 is Tavarius Thompson. Tavarius Thompson, 25 PI 000285. And I'm sorry, this has been indicted now, so it's 26 SC 000665. It's the son of Judge Cox. All right, what about it?
What was the last four of that indictment, Your Honor?
It's 000665.
Want to be in Judge Cox's courtroom.
What about it, second chance?
So defendant was here for compliance on
I don't know.
2-2, and you approved for defendant to stay
It
at the
must
3
have just
separate
gotten done.
locations due to his housing issues. Defendant has been staying at these locations, but he has not been abiding by his 24-hour curfew. Since the compliance hearing, the defendant has had 19 curfew violations. He's being tracked at other apartment complexes, fast food restaurants, residential homes, gas stations, and even lounges, which are in violation of his 24-hour curfew. I would like to state that the defendant's travel on some of these curfew violations are in the wee hours of the morning between the hours of 12 a.m. to 4 a.m.
All right, lost it. Pre-trial.
Judge, the last time he was here, you put him in custody.
Oh, I did.
Yeah, he was in custody for 3 days.
But now,
Arrested.
here we are back again.
Oh, state's recommendation is gonna be.
Go ahead, counsel.
Well, Your Honor, Mr. Thompson does state that he is, he has housing issues, that he's moving from place to place, and that is the reason why he does have the curfews, because he is, at this point, homeless and is trying to find a place to stay. And so we would ask the court to just continue to monitor. The case has been indicted, and his attorney in Judge Cox's courtroom can then file whatever other motions that may need to be filed.
But explain to me how his violations are in the wee hours.
This courtroom hearing starts with a routine bond discussion. Ankle monitors, house arrest conditions, and attorneys arguing over supervision. But then everything changes when the victim's family begins speaking directly to the court. A young woman named Venus steps forward and calmly describes what drunk driving took away from her family forever. She explains that everyone already knows the risk of drinking and driving. There's no confusion about it. We know you don't drink and drive. Then the courtroom becomes emotional, fast. She talks about losing her mother at only 23 years old while trying to raise children of her own. Her mother wasn't just another victim in a police report. She was the center of their entire family. She was our anchor. My mama was my everything. The daughter struggles to hold herself together while explaining that this case isn't just about a hit-and-run charge. A real person died. Children lost their mother. Grandchildren lost their grandmother. And no matter how accidental it may have been, someone still made the choice to drink and drive. Then comes the hardest line of the entire hearing.